Good evening, everybody. Thank you for coming out to Intergenerational Family Co-Ownership and Estate Planning Considerations with Richard Bell, put on by Coho BC, the Collaborative Home Ownership Initiative. I'm Noam Dolgan. I'll be your host today. I am affiliated with Coho BC and a realtor focusing on sustainable real estate solutions, socially, environmentally, and economically sustainable choices in housing, and a firm believer that co-ownership offers that pathway. I'm delighted to have Richard here with us tonight to talk about this particular form of co-ownership, of family, and specifically intergenerational family co-ownership. And thank you all for being here as well. Before we get too deep in, it's important to acknowledge when we talk about land ownership and land stewardship, and just in general, our standing here in British Columbia, that this land that we're talking about is the ancestral, unceded, and definitely beloved territory of many different nations across the province. And while we understand that property ownership is a complicated socially and political thing, we take great pride in our role as stewards of this land moving forward when we choose to acquire land for ourselves or for our family. So what is Coho BC? For those of you who are at one of our events for the first time, Coho BC works to promote co-ownership as a viable and valuable housing option for people across the province, to provide resources and professional support to assist groups going through the co-ownership process, to assist in the creation of co-ownership groups through a dating pool, a chance to meet other like-minded individuals or families, and to facilitate the resale of shared property interest to other potential buyers and partners. In this case, when we're talking about family co-ownership, where most of you probably have the people in mind that you would be looking to buy with and may not be looking to resell shares to a third party, we're of course going to focus on how co-ownership is a viable and valuable option and how it can work, and the kind of resources and support that we can give you in the acquisition of property or the transition of property from one owner to a family. So who we are is a collection of professionals, all with experience and expertise in collective housing and co-ownership, who've come together to provide these supports and these resources and to help you through the process so you don't have to reinvent the wheel, but you can use the experts and set yourself up for success. We're realtors such as myself, lawyers such as Richard, builders, financial institutions, architects, mediators, and more, who really see this as a pathway forward for a fairly large percentage of the population. So before I go too deep in, you're hearing a lot of my voice. So who am I? My name is Noam Dolgan. As I said, I'm a realtor in Metro Vancouver with a specialization in co-ownership, sustainable living, work a lot with first-time home buyers and also families and downsizers. So really across the board, real homes for real people and outside the box real estate thinking. As I said, I come into this from a sustainability mindset because before entering real estate, I worked in environmental education and institutional greening and community engagement and development. So environmental sustainability, social sustainability have always been key to how I think we relate to the world. And then coming into the BC's expensive real estate market, financial sustainability clearly is an obvious important piece of it. And you know, the home that you buy, the place that you locate yourself, is the biggest decision you will make in your lifetime, economically, socially, and environmentally. So helping you get it right and set yourself up for success along the way. Our guest speaker tonight is Richard Bell from Bell Alliance, the experienced real estate lawyer here in Vancouver and an innovator in this field. Richard, why don't you introduce yourself?
Good evening, folks. Yeah, so I have a law firm, team about 70, 75 people. We do a lot of residential real estate. We do a lot of estate planning work, and so I'll bring those two pieces together. I'm past chair of an organization called Small Housing BC. That's been a anniversary this year, is our 10th year anniversary. We've been aggressively promoting the densification of single family lots. I'm also president of an organization called World Housing, where we build housing in other parts of the world, primarily in the developing world, but also in Canada. So I'm passionate about this. I built the Bell family compound, and you punch that into the internet, you'll probably pick up some video content. We've been on the front page of the Globe and Mail and CTV a couple of times, and pretty passionate about moving this sort of initiative forward. Um, that's what I do.
Thank you, Richard, and thanks for taking your evening out to talk to us. We also have today with us David Hale, who is a Coho affiliated realtor in the Victoria area and the founder of Shared Home Ownership Victoria. David, I don't have a slide for you. We'll take a moment to introduce yourself.
Sure. Good evening, everyone. David Hale, Shared Home Ownership in Victoria, and been a realtor here for more than 30 years. So I've seen some major growth in the area, and Noam and I've been working together for a few years now on this concept of co-housing and shared home ownership, and I really believe that it's the wave of the future. And with the prices here, it's about 1.3 million is the average home. I know in Vancouver it's probably 1.7, 1.8 or so. Pretty crazy numbers to try to get into, especially for first-time buyers. Pretty well impossible. You've got to have family money behind you heavily to be able to do it. So this is a viable way to get your foot into the marketplace and build some equity. And as we know, most people have built their wealth with real estate over the past. So glad to be here tonight. Glad to be part of this whole program.
Thank you, David. And David and myself are just two of a number of realtors across the province who are affiliated with Coho and would usually be your first step in to find out, what kind of housing is available at what price that might suit the needs of you and your various generations. And we'll be happy to talk to you at a later date about your real estate situation. But we're not here to talk about that. We're here to talk specifically about what family co-ownership can look like and what are some of the considerations you need to keep in mind as you go into it. So what it can look like is really up to you, right? Common examples include communal living, so where we see multiple generations under one roof. Certainly common historically as a form of ownership, grandparents living in with the kids and grandkids. And certainly very common in many of the first generation Canadian communities across our region. And that can really work for many people. You can certainly do it without co-owning, but a lot of times it makes sense for most, if not all, of those members who are living together under one roof to be on title and to contribute and to be partial owners. So if you're doing that, definitely a way, there's things to consider in collective living. What we're seeing more and more popular, and what Richard did a great job advocating for in his work with Small Housing BC and before that, is the family compound, where we can have multiple dwellings on a single property. So traditionally, that could be a duplex. For the last 20 years or so in Vancouver, that could be a house with a laneway house or a house with a basement suite. We also have some historic homes that are divided into multiple suites, like Vancouver Specials. And now with the new zoning across the province, we're seeing the 4 to 6plex, the multiplex, become a viable housing option in much of our zoning. And so that's a great way to, build housing, single story housing for a, retired couple or single, and while creating maybe a 3-bedroom townhouse situation for the child who has a family, and maybe an additional 1-bedroom unit for an additional child in the family. And then, as big your family is, and we sell off a couple of the units to pay for this development. There's a lot of flexibility in that model. So you can live communally, you can live in multiple dwellings on the same property. What we're of course seeing common, and has been common for many years, is the bank of mom and dad, where parents invest in their children's property. Historically, when prices were lower, that was often take the form of a gift. But as prices have gone higher, and let's say you have one kid in Saskatoon and one kid in Victoria, and you have very different needs of what they each need. Maybe co-ownership is a better pathway than gifting the monies. Also, to qualify for financing, especially with these higher rates, we're seeing more and more folks turning to parents, not just for the down payment, but also to qualify for financing going forward. And so to do that, they generally need to be on title. We don't have the old guarantor system as commonly anymore. So this is, in fact, a recent report came out that showed that of people born in the 90s who own real estate, a third of them own in this capacity, own in combination with a parent. And so this is clearly very common practice across BC and across Canada. And I mentioned earlier kind of duplexes and multiplexes. Those can often be stratified, which means you don't have to co-own. You can have separate units with separate legal title on one property. But to actualize that vision, oftentimes you go through a co-development stage where you acquire a piece of land together, you build out your dream compound, and then you move in and have separate titles. So co-ownership can be an end goal if it makes sense given the housing types and the price points, and can also be a stage towards an end goal that was with separate legal title. So why would you co-own? Always an interesting question, right? There are many advantages to family co-ownership in particular. The big draws are to help children get into the real estate market through down payment or mortgage qualification. I just mentioned that. To stay close, right? To stay close to your family, to create mutual support systems where grandparents can support with care of grandchildren at a certain stage in life, and children can support their parents at a different stage in life. Someone can go out of town, someone else can look after the property. But in general, right, why don't we live close to our families anymore? It certainly has always been historically a way to go, and it creates social bonds, and it creates a better quality of living for many people. And so co-ownership can help you actualize that. Through co-ownership in general, you can get more for your money. So instead of having to pay the premiums for a strata-owned half duplex or townhouse or condo somewhere, you can get more space, or get access to a yard, get access to storage, garages, farmland if you're in a rural setting, whatever it might be, that you just couldn't access if you were buying into the traditional strata market. This pathway can be a great pathway to help parents stay in their home or in their neighborhood. So people who've lived in a single family neighborhood for many years and now have a 3,000 to 4,000 square foot home they don't need on their own, right? There's a pathway for them to move into a garden suite or move into a laneway house or build out on that site and access the equity for their retirement, stay in their home or in their neighborhood where all their support systems are and which they love so much, and of course bring their kids closer and maybe into a part of town they could never otherwise afford to live in. And as I've said a few times already, live more sustainably, personally more sustainably, with family close by, socially, economically, and environmentally. So what you're here today to talk about mostly, though, is how do you protect yourself? What are the considerations that go into that? And I will turn the floor over to Richard very soon to talk about some of the broader considerations. But just quickly, even families need to make sure they have their legal ducks in a row. They need to have a proper co-ownership agreement, a proper vision of how the property will be used, who will be responsible for what happens if something terrible happens and someone dies, divorces, loses a job, or just realizes it's not the right fit for them and wants to move on. So planning ahead, many people think that you don't need this for families because, oh, it's family, we're in it together anyways, we can always work this out, and so they go ahead without a co-ownership agreement when they're with close friends or family. And I like to think it's the opposite. You need it even more with a family member because you have that much more to protect. It's not just your investment, it's not just your asset, it's also the primary relationship in your life that you want to protect. And if something goes sideways down the road, you want to know that you have a system for it in place so that you can just look to your agreement and say, oh, this is what we're going to do, and it doesn't create conflict. if you don't have a plan and all of a sudden there's a disagreement over who's responsible for what or who's paying what or someone can't pay, you got to deal with it then at that hard moment when maybe the relationship isn't quite as good, or just in general when there's this additional third party stress, coming up in your life. It can really put strain on a relationship. And Rich was this as well, but certainly when it comes to estate planning, right? When it's a lot easier to plan in advance, to to understand how your assets, in this case your real estate, will be allocated, instead of the kids having to figure it out at one of the hardest times in their life after their parents have passed. So Richard, if you want to chime in about any of these things in particular, or say some of the stuff to your broader presentation, but the things that go generally into a co-ownership agreement include the financing, right? So what's everyone's initial contribution and how are ongoing contributions going to be allocated? So if you're all living in the house, then that might be, based on how much space you occupy, but maybe, the kids have less money to contribute, but they're going to contribute more in terms of monthly payments. If it's a place where you're investing in your kid's home and they're not living there, are you responsible for any of the ongoing payments, the taxes, the insurance, or is all that the responsibility of your kid who's living in the house? You're just putting your money in as a down payment. All that, what you're financing and how it's being paid for, all needs to be, made clear in advance. Of course, your percentage of ownership, often that allocates to what your initial contribution was on a property, but not always. Again, maybe you're going to pay down a mortgage over time. Your parents are going to come in with a whole lot of cash. So you want to figure out what is your ownership, and then again, how that relates to your ongoing responsibilities for financing. What's your form of ownership? When you come to families, we often see joint tenants. Joint tenants is where you have a right of survivorship. So if one person passes, the property passes on to the other person who's in that joint tenancy. So that can be great if a parent has only one child. But if a parent has multiple children, do you do joint tenants and then create another thing in your will to offset that? Or are you do tenants in common, where each of the pieces is a separate legal entity? When someone passes, it passes into the estate of that person, or some combination. Often, like a couple will be joint tenants, the parent couple, and the kids couple will be joint tenants, and then there'll be tenants in common between them. So figuring out the model that makes the most sense based on your situation. The purpose and vision, what does each party own, right? What is your exclusive space? What is your common space? What is the timeline of this purchase? Are we doing this with a 30-year timeline or a 5-year timeline? Just making sure that everyone's on the same wavelength for how the property will be used and what the goals are. Property management, who will be responsible for taking out the garbage, who's going to pay the bills, who's going to do the repairs. This is one of the advantages of living intergenerationally, of course, is that, let's say when the older generation is young enough to be active, but old enough to be retired, then maybe they can take care of a lot of the stuff for the other family who's busy with kids. But then when someone gets too old or unable to manage that stuff themselves, the next generation can step up. So is that joint? Is it on one of the two parties, etc.? Similarly, your respective roles and responsibilities, and your shared resources and expenses. So how are you allocating expenses? Is it, again, based on ownership stake, based on occupancy stake, all on one party? How does all that allocate? We'll go on. I'll try to speed it up a little bit so we can hear from Richard. The rules, what rules and visions will guide the partnership? Quiet hours, no smoking, a vegetarian home, energy efficiencies, whatever it might be. Delinquency, a very important piece, right? This is when we start getting into the backup plan here. So what happens if somebody stops paying the bills? And someone else has to cover them for a while? How does that play out? We have systems that the coho professionals can help you with, and that the lawyers will help you put into your contract that specify, you'll carry your partner for a while, they'll pay a certain interest rate, then they can buy you out. If it goes too long, you can force them out of the property. So there's all these systems in place to protect you in that situation. Social framework and decision making, are all decisions based on consensus, or is there a supermajority system in place where you have a vote? Conflict resolution, when might you bring in an outside mediator? And then worst case scenario planning. A lot of this becomes worst case scenario planning. What happens upon death, divorce, relocation, etc., of one of the parties? And this becomes a very important piece, especially again intergenerationally. Death becomes a more common and realistic thing. And if it's, let's say, one family's property and their child has gotten married, how do you deal with the potential of divorce with that partner? What is their stake and what is their rights in this situation? So a lot of this stuff that's very specific to into a family compound situation or family ownership situation that you want to make sure you've thought through with professional support and written into a solid legal agreement with an experienced real estate lawyer, so that you don't have to deal with it on the spot. And then, of course, exit strategy. How do you create it? What's your system when one party is ready to move on, or, as I said, has to, gets relocated for work or whatever it might be? There's generally a three-part system, something like this, or two. The one is a first right of refusal, where your partners can then buy you out of the property. The second is the right to sell to a third party, which becomes less realistic in a family compound or a family situation that you're going to bring in a third party, but it's something we're seeing more and more commonly, generally in friend and stranger co-ownership arrangements. And then the third stage is if your partner can't buy you out, you can't find a new person to buy in, then you have the right to force a sale in the property as a whole. Say, this has been great. We've had a wonderful time together as a clan for the last 10 years, but now work's taking me to Ottawa, or, dad needs to move into supportive housing, or whatever it might be. And then you go your separate ways. So that was a long introduction to intergenerational family co-ownership, but that hopefully will give you a good foundation for what Richard has to say, where he can build off of some of those basic concepts and help us think about other considerations that we hadn't thought about along the way. So Richard, thank you once again for sharing your time with us and your expertise, and we look forward to hearing what you have to share with us.
Well, Noam, that was a heck of a summary of what needs to be in a co-ownership agreement. I think you've been working with a few lawyers to be able to list all those items. So whenever I talk to a group, I really start off with not so much the co-ownership thing, but just in terms of the estate planning side. And I'm particularly sensitive to this because most people haven't done a good job of preparing for something going wrong. And, last week, I ended up at VGH on 2 occasions dealing with clients that had not properly prepared, and then another client in hospice. And so I'm dashing over there to be able to get their estate planning documents together, powers of attorney, wills, etc. So who's ever listening to this, I just encourage you to truly look at the documents you've got. If you haven't done them, you should do them. If you have done them, but you haven't looked at them in 10 years, you probably should be looking at them. In my practice, which is now probably 90% estate planning, which has probably got something to do with the gray hair and having done real estate practice. David, you said you've been practicing for over 30 years in the real estate business, and I still say I've practiced for over 25 years, and it's quite frankly significantly longer than 25 years, but it always just sounds nice when I use the lower number. So truly take a look at wills, powers of attorney, representation agreements, particularly for the older audience. How can you avoid the probate process? And there's a couple of techniques of doing that. And often people simply don't want to pay the government 14,000 per million on the value of their estate. So just truly something to look at. So in terms of co-ownership and multi-generational living, Noam in one of his early slides talked about some of the benefits of that. And I think anytime you want to go onto the internet and check out to Bell Alliance Compound, you'll see my family. I have 4 generations living on a property in Vancouver, everything from a 4-year-old granddaughter, 6-year-old granddaughter, 2 daughters, a son-in-law, a 96-year-old mother who I take care of. And I can never forget my 70-pound dog, which is as much work as my 96-year-old mother some days. And I think it's the dynamics of that are challenging. Everyone has to recognize that the family, the players are different, and when you bring an in-law in, there's again that added difference, which quite frankly has just been incredibly successful for us. But you get scenarios like my mother has to go into emergency every 18 to 24 months, and so where's the family? Who can hop in the ambulance? I'm at work. I can get over to emergency for 3 p.m. Another family member can take care of the grandkids, and just, the support of nature. And then on the other end is, my daughter and son-in-law. Gee, it'd be nice if we could go out for dinner sometime, and do you mind taking care of the kids? Or one of the kids has a challenge. So it really is it's a special arrangement. I somewhat jokingly say 90% of the time I think was a really good idea, and the 10% I think I must be just in a bad mood or something. But I sort of highly recommend that. Now, what I did, just as a perfect example of how we're structured in the family compound, is that both my kids and my son-in-law own part of the property. And what I did is I gifted them part of the dirt. And then I had the contractor calculate the cost of each unit. And then we put a mortgage on the property so that each child is responsible for the cost of construction of their unit, but not the cost of land. There's a great quote by Warren Buffett, which basically says, help your kids, but don't help too much. Because it is the baby boomers' kids that are challenged by being able to own property in the community in which they've grown up in. You look at these different categories of population, and of course the baby boomers were just a massive spike. But what's known as Generation X and millennials, they occupy 40% of the population. So that's a massive segment of the population that would like to get into home ownership. But as we all know, it's just become so expensive, and that's why this co-ownership concept has become so popular. My understanding is when you look at laneways, probably 80% of them are family-based solutions. So in my case, I have two daughters, and they're all owners of the property, and no mention these different structures of joint tenancy and tenants in common. So what we have is that one of my daughters is not married. She owns a tenant in common interest with everyone else. I own a tenant in common interest with everyone else. But my other daughter and son-in-law, they own a tenant in common interest with my other daughter and me, but between them, they own a joint tenancy interest. So you can mix those types of ownership. Normally, spouses will own joint tenancy in real estate, and when one of them passes away, it automatically goes to the survivor. So there's a number of different ways of structuring title, and we as lawyers and the professional realtors who deal in this space or have a really good grasp of that. So my situation, pretty simple. I've got two daughters and they're all participating in this. So the challenge becomes around estate planning is what happens if one child is going to be part of the family compound and another child lives in Toronto, New York, or wherever. And so you have one child who is being given an opportunity to participate in the increased value of real estate in whatever town. I'll just use Vancouver as the example. We all see, aside from a few moments in history which come along every 8 to 10 years, when properties actually pull back a little bit. But by and large, property values throughout the country just keep on going up. So if you have one child who's participating in that opportunity and the other one is not, there's a couple solutions. One is give the other child a whole bunch of cash today. Well, that's often unrealistic because so many of the baby boomers, their wealth is tied up in their real estate. So this is where we start to look at adjusting in the will to basically look at and say, okay, when the last parent passes away, what is that child going to receive under the will, the child that wasn't participating in the increase of value of real estate? So we have ways of building clauses around, let's look at what that value is at death, and the one who's participated in the real estate, where are they at? What have they essentially received by being on title? And then we adjust that amount into the will. So a couple of different ways of doing it depending on the specific circumstances. And what I found is that although there's some commonality in each of these scenarios that we work with, there's also so unique aspects to them. So we're really very careful about that. Here's the one challenge around co-ownership is that there is one legal title, and therefore there's one mortgage. And that can work out fine in terms of families, as opposed to friends coming together, because everybody who is an owner is, from a debt service ratio point of view, is 100% liable under that mortgage. And I always smile when I start to tell the story. So in our case, we put one mortgage on the property. Each child's responsible to make the payments on that. But when it comes to a child deciding to buy a new car, the car loan people, the ones that are doing the loan, look at what is the debt service ratio of that child. And they treat it as the child is 100% responsible for the total mortgage. So dad gets the phone call, Dad, would you like to buy a new car with me? And of course, dad says, sure, just what I need, another debt on my records. So that's a bit of a challenge. I'm sure everyone on this video has followed a bit of the story of the changes in bylaws and legislation, which will allow for densification. The legislation doesn't, the provincial legislation doesn't require that municipalities allow for stratification. But most municipalities seem to be going down that path, that they want this initiative of gentle densification to be successful, no matter what they may say in front of the TV camera, because all municipalities are struggling with the same challenge. How do the next generation get to live in the community they grew up in? So what the advantage of the change to allowing for stratification, assuming the municipalities do, is that you have separate legal title to each unit. So if a family comes together and they build 3 units on it, and parents have one and each child has a unit, then that they're responsible just for the mortgage on their property. And so there's a structure that we look at when family are doing this and they're going to stratify. We make sure that the kids are on title before the redevelopment. And this just avoids some capital gains tax issues once that ultimate strata plan is filed. And many of the things that Noam has identified in terms of what needs to be in the co-ownership agreement just follows, and there's dealt with through the strata legislation and the standard form of bylaws. So each person who's an owner becomes liable for just their mortgage. And so again, you look at where you've got a child who's not going to be living on the property. They could actually own a unit, and it could be a rental unit. And they may be planning to come back to the city at some point in the future. So it just creates a little bit more flexibility. But if you take an existing property and you can divide it without, in one building, where you can create 3 units in one building, then the opportunity to stratify really isn't there in most instances. So this is something that we're going to see. It's just the reality of life is that people who grew up in their community, by and large, can't afford to buy in the current sort of structure that exists out there, which is basically single family zoning. And so the province has stepped in and had a big impact to encourage, gently prod the municipalities to move forward with these changes. So Noam, that was sort of what I wanted to cover off, but certainly open to any questions that anybody has.
Fantastic. And we'll open it up for questions in a moment. At, at the moment, we have our security settings high, but we will lower them down and allow you to unmute yourself and speak up. I'm just going to start though. If you could talk a little bit about how you plan for how you would plan in terms of exit strategies for death and divorce specifically, because those are two things that I think, especially when it comes to intergenerational family real estate, are highly likely scenarios. I mean, death is unfortunately always a likely scenario, but more common when you get into this age of investor. And divorce, which is now 50% or more of married couples. So what kind of considerations would you say people have to put in? How do they structure the legal agreement to keep those situations in mind?
Yeah, so parents, and guess what's in my co-ownership agreement is dad has the option to trigger a buy. So if there is a divorce and it's not getting resolved in a reasonable time, I have the option to buy out at fair market value, so that the the in-law will get his or her value out of the property, but it gives the parents control over that. Death, the challenge becomes, so if mom and dad have passed away, and there isn't a child who is participating in the redevelopment of the land, for them to get their share of the inheritance, that the value of the parent's interest in the property needs to effectively be converted to cash. And if the other children who are participating in the co-ownership structure can't afford to buy out the parents, deceased parents' interest, then ultimately a provision has to allow for the overall sale of the property. Again, strata helps with that. Similarly, if parents have to go into care, they need their equity out of their co-ownership interest to be able to pay for care. So again, does the property have to get sold? And again, this is why the stratification structure creates a little bit more flexibility than the co-ownership structure. I think that's the two big challenges under co-ownership is that everybody's responsible for 100% of the mortgage. And within family, by and large, that's not a big issue. But if you have friends coming together to be able to redevelop a property that they've bought together, then that's an issue. Parents have to go into care, parents pass away, divorce, all of those things have to be talked about and solutions drafted into the agreement.
I love the model that you have of allowing, of having that, dad has the power to pull the trigger on anybody who's problematic. You do see a lot of the collective, like the larger group co-ownerships have some sort of supermajority where if, 4 out of 5 people feel like one person's not the right fit anywhere, they can force them off the property. It's harder to do in smaller groups. But yeah, that realization, again, every legal structure is unique, every situation is unique, and you don't have to all be equal.
Yeah, and there also is a piece of legislation called the Partition Act, where if someone says, I need to get cashed out, you can't afford me to buy me out, let's sell the property. And if that other party says, well, I don't want to sell the property, then you can go and get a court order under the Partition Act, which will force a sale of the property.
So best to just preempt that and have a plan in place from the beginning.
Yeah.
And I've also seen people do something where, so upon the death of one of the parents, I guess of both parents or whoever's the
Just saying
owner.
good night to my mother.
Good night, Mom.
Good night, Mom.
Good night from all 20 of us. So I've also seen people put a rule in their will, which basically allows for that interest to stay in the estate for a period of time and hold a sale off for an extended period of time. Because you know, at these worst times in your life, your parent has just died, you're dealing with all of their logistics. Maybe you have to deal with a sibling who you don't always have the best relationship with sometimes. And just in that moment, you're like, oh, now I got to get out of my house, sell my property, and get that going. So I've seen people put in a 2 or 3 year clause where, you know, where you do have to either buy your sibling out or sell it, but you don't have to do that right away. Is that a common thing you see?
Yeah, that's a good comment. We use that structure in the co-ownership, but we also just use it between a couple that have perhaps second marriages and all of that, where there's a period of time for settling, um, uh, giving people the opportunity to grieve and to plan. And, usually a 2-year window seems to be sort of an average. It's some are 1, some are 3, but I think 2 years is sort of an average that we see.
Fantastic. So I've opened up the video. You can turn on your video. You can send a message in the chat if you've got questions for us, or you can raise your hand and share it verbally. I'm going to ask one more while we wait for people to get unshy and ask their questions. We see a lot of co-ownership by circumstance or by ownership just by inheritance, right? Where parents own a vacation property, usually it's a vacation property more than, let's say, the primary residence, because that often gets sold, but own a vacation property, and then it's included in the will, and it's inherited by 4 children, or then it gets down to inherited by 16 grandchildren. And not everyone wants to sell, and people don't want to go through the courts to force a sale. So what advice do you have for people when they're estate planning, when it comes to properties that they're planning on willing to multiple children, and so these children will be in a co-ownership situation down the road once they're gone?
Yeah, so it's probably one of the situations that creates more challenges between siblings than any other issue around estate planning. Um, and as you mentioned, it's very few scenarios where everybody wants to equally share in the opportunity of a vacation property when you've got 3 children and there's a vacation property. So again, in some instances it does work. And so what we end up with is creating a usage agreement. Who gets to use it when, and what's the contribution of the costs and everything. But it is probably one of the most challenging things, because the parents would love to see their kids continuing to use it. But as I say, very seldom do I see where all of the children believe that they're going to be able to use it equally, or if unequal, that there is there's usually a heated debate as to who's covering what percentage of the cost is one party going to cover. So it tends to, if any of the children can't afford to buy out the others, my experience has been that there are a few successful scenarios, but I would say that the majority of the ones I see don't end up being a happy outcome over a couple of years.
So what can folks do to preempt that, right? Not to just let it go into the estate and let the kids figure it out down the road. What can parents do now in their estate planning to kind of set their kids up for success?
Yeah. So, it's really easy if the parents' estate is large enough to allow for the kids that don't want to play in the vacation property to get cashed out, or if there isn't enough money in the estate to do that, that the ones that want to keep the vacation property have the financial capacity to borrow and to pay to cash out the siblings. And if neither of those two options work, then ultimately you end up with hiring lawyers and forcing a sale of the property. So it's vacation properties are a huge issue, and these changes in the capital gains tax rate has had a fairly significant impact on the tax consequences to the estate when the last of the two spouses pass away. I think everyone has seen the media about going up to taxing 2/3 of the gain over and above 250,000, which for a lot of these vacation properties, Whistler's a good example. They've gone up significantly in value.
Okay, we got our first question here in the chat. Very practical question. What does it cost to draft a co-ownership agreement? And if you have two parties, does each party need a separate lawyer?
Yeah, so it depends on the relationship between the parties. They can waive independent legal advice. But I think you think in terms of about $5,000, $5,000 to $6,000 to do up a co-ownership agreement. It tends to be because everyone is unique. It always astounds me how there's these little differences from one scenario to the next. But that's a safe number to work with, is the $5,000 number.
And I will say that's one of the reasons why, if you're doing this, you should be working with a Coho affiliated real estate agent, because while we're not lawyers, you still need to hire a lawyer. We can help you address the questions in advance. As Richard was saying, it was a pretty thorough list of all things that go in there. We can, as part of the service in the acquisition of real estate and getting paid through that, we offer free consulting on what is our vision for co-ownership agreement, how do we want to structure this legally, how do we want to structure it socially, and you can have most of the big conversations in advance and take a plan to the lawyers, which hopefully can cut $1,000 of their time having to facilitate conversations with you and answer these questions with you out of the bill. So the goal is to bring that cost down to $3,000 for people if possible, but it's often not doable.
You have no idea. Yeah.
Going back to our presentation. Please do put your more questions in, or feel free to raise your hand and ask your question directly. David, did you have anything you wanted to contribute or ask of Richard?
Hang on a sec here. Oh, there we go. I guess our agreement's about 3.5 years old, almost 4 now. We're just, of course, worried about our interest rate. It was at 1.89%, so
yeah,
it's going to go up. If we're lucky, our mortgage will double. But yeah, I guess with us, ours has been pretty easy. So we had a younger couple come in with a younger child who's 5 now, and they're going to want to stay. They're going to want to extend the agreement for another 3 or 5 years because there's the school right across the street for their little one. But yeah, give me a sec. I'll come up with something for Richard.
No problem. We've got a few good questions that have come in the chat, and Jennifer has her hand up, so I'll throw one from the chat first, and then Jennifer, I'll turn it over to you. So the first question here is, and we talked about this a little bit, so maybe you can go a little more details. Please say more about divorce proofing and protection strategies for both generations. You have other suggestions for how to divorce proof?
Your question.
So do you want me to
Richard?
provide some? Yeah. So one of the big changes in legislation was an amendment to the Family Law Act a few years ago. And so the previous legislation that is basically a standard right across the country was that regardless of who owns a property or an asset, the presumption is that it's a family asset and therefore split 50-50 between the parties. What the amended legislation provided was that gifts and inheritances, the presumption does not apply to gifts and inheritances. Now, what happens is if, after a gift or after inheritance, if there's been a co-mingling and the couple is breaking up 20 years later, I'm pretty confident that they're going to be treating it almost as it would have been treated under the old legislation. So when someone decides that they're going to add a son or daughter to title under a co-ownership, then that legislation would provide some protection. But the best protection is to have a cohabitation agreement, so if you're putting both your kids on title, recognizing that if there is in fact been a gift, that your child gets that asset back. So that's it's a good question. We're constantly asked when Bank of Mom and Dad are helping kids buy into a property, whether it's co-ownership or otherwise. We will sometimes do a promissory note, which is payable on demand without any interest. So at least the parents' investment in helping their kids can be recovered in the event of a divorce. So that's a pretty standard mechanism we use. But that together with the change in the legislation and a cohabitation agreement between the kids, tough for your child to lose the battle around is the departing spouse entitled to anything. So those three things make a big difference.
I would just add, there's also the flip side of this, right? Is for the spouse who's getting into a co-ownership arrangement with a whole bunch of family members and is nervous that if something goes badly, they're going to get screwed in the operation because everyone's against them and they're just a 5% owner, a 10% owner. And again, I think the law entitling them to, their share of whatever appreciation has happened over the time, and a co-ownership agreement that explicitly lays out, upon the resale of a share, here's how your share will be valued, and here's how it is an important protection for that half as well, so that they know that if they split, they may not get their, the parents' share of a deposit back, but if they put their own down payments in, they're going to get that back, and that they won't be, screwed. They'll be able to go and buy themselves a condo for their kid going forward.
Yeah, no, absolutely. That'll be in the co-ownership agreement.
All right, Jennifer, you've very patiently had your hand up. I would love to hear your question.
My question is, we own a farm up in Sorrento, and we have 5 kids. And I'm wondering if you had any experience with co-op as an ownership structure, even in a family.
No, I mean, in the big city, we have a few old co-op structures, right, where it's registered under the particular co-op legislation, and people own shares in the co-op. The challenge with co-ops is financing when the bank's not able to get a charge against title from an individual co-op owner. Their security is in the shares in the co-op. So that's so probably, if that's the first time someone's asked, well, we don't do a lot of farm properties, I guess is the story. But using that as opposed to a tenant in common interest, I guess I'm not sure why you would go that co-op route as opposed to tenant in common.
Yeah, and Richard, I'll add to that. So we see a lot of interest in co-op because ideologically it seems fantastic on stranger or friend groups getting into environments. The biggest challenge is financing, as Richard just said. It's definitely harder, if not impossible, to finance your share, and much harder to finance the whole versus you can't do traditional residential financing, bank mortgage financing if it's a co-op structure. And you can't easily get corporate financing either, like a traditional commercial financing, excuse me. So what we do see is people who are looking at the co-op model end up generally going with a corporate model or a company model where their kids would own shares in the property, and therefore, the company owns the property, and there are some advantages to that: easier title transfer, some easier, but there's also challenges to it, like accounting issues, and again, financing becomes harder. So we could talk about your personal situation, but basically, almost always, if tenancy in common is an option, if it's less than 8 or 10 co-owners, where you really have to get into a corporate structure, generally the advantages of a tenancy in common, because of the easier to finance, lower financing rates, easier to resell shares, things like that, tends to be the preferred model.
Okay.
Um,
We could, with 5 kids, we could end up with 12 members, right?
Yeah, so if you have 12 separate members on title, then you start to want to look at corporate structures, because otherwise it becomes very hard to get insurance on the property with that many properties. It's very hard to get financing. I mean, it's already hard to get financing as a corporate structure, maybe impossible, but it's very difficult with 12 people on title to get financing, and they don't all want the $1 million against them or whatever it might be. So yeah, it could make sense depending on the structure, but generally you'd be looking at a corporate structure, not a co-op structure. The co-op structures tend to add more complications than advantage.
Yeah.
Okay, it's good to know. Thank you.
So on that topic, there was a question here from Janice about the difference between strata structure and company or corporate structure. So you want to talk a little bit about what strata is? You want to define for us?
Yeah, I mean, just think of your standard apartment building for the units being for sale. They're stratified units, and I mean, when you think about, borrowing money, the banks are always think about what happens if this person can't pay me back. And so again, one of the advantages of the strata, there's a market for it. And one of the disadvantages of co-ownership is that if someone can't afford to pay their share, what's the marketability of that? You think about, these tenant in common and vacation properties. So for example, at Whistler or some of the Gulf Islands, you can buy a 25% tenant in common interest. Not a lot of lenders, but some of the lenders will finance that because they see there's a market for it. Someone will buy a 25% interest in a condo at Whistler that's being managed professionally, and they have certain months that they can use the property. So those things, but as soon as you get, sort of into a bit of a unique structure, financing is really tough. I mean, I think, Noam, and correct me if I'm wrong, probably Van City is the only body that will finance a co-op. They're just getting shares. They're not getting an interest in the real estate. They're getting an interest in the shares, and most lenders just don't want to have anything to do with that. And there's a discount. They're a little cheaper. Those properties are a little cheaper, in fact, because they're not as marketable.
Yeah, and Van City is one of the few, and unfortunately, if you weren't put on the co-op list that was finalized in 1985 or whenever it was, your co-op doesn't get approved for it. They don't have a mechanism for adding new co-ops to their system. So I have been able to get financing through other small credit unions and other options for these unique situations, but it's very, very hard. And again, that's why you want to work with the specialists here. But okay, thank you. I'm going to, as a follow-up question here to the cost of a draft agreement, and then David, we'll turn to you next. Is it possible for the parties to draft up their own co-ownership agreement and then just get it verified by a lawyer and lessen that $5,000 charge?
So here's my rule number 1. If I have to work with someone else's document, it's going to cost them more money. And that's just that, we have probably 15 different versions of co-ownership agreements, and we still have to play with them. This comes up, people say, well, I've drafted a will, and I go, so what about disability clauses and these different clauses? Oh, well, and and it's not, it is the reality of it. I mean, I say it jokingly, but the reality of it is it takes more work to work with someone else's document as opposed to the precedents that have been designed over the last 15 plus years for co-ownerships by law firms that do this stuff. So it's,
And I would just say that it's an insurance policy, right? Like you can have the conversations and come up with an agreement and get it signed by all parties and even notarized so it has some legal basis, and just decide that, when the time comes, you're going to refer to your document and you're going to utilize it. And therefore, as long as you've had the right conversations in advance, does it need to be a legal document? Well, probably 9 times out of 10, or maybe even more than that, it won't need to be. You're never going to get anywhere near the courts. But there's two major reasons to deal with the lawyers. Number one is to make sure you didn't forget anything, right? To make sure that you've got all of those considerations thought through. And number two is if it ever does get bad enough that it ends up in the court. So hopefully it's a waste of money, right? You never have to use it. You never end up in the courts like insurance. The most frustrating expense we all spend every year, because hopefully we never use it. But you definitely want it there in case you need it. Because a
so
couple
here's
times,
another good example of the family compound. My oldest daughter just took my 70-pound dog for a walk.
nice, saving you.
Saving-
Yeah, and I was gonna say, so we do every, I get calls every couple of years, every couple of years when we hear about in the courts a co-ownership situation gone poorly, right? And they're like, see, co-ownership's a bad idea. Look, these people are fighting over how to do it. And inevitably, these are folks who don't have a legal co-ownership agreement, right? They don't have a plan most of the time, but they definitely don't have that legal contract. So they had that legal contract, they generally wouldn't end up anywhere near the courts. I mean, Richard, of your clients who've come to you to develop a contract, how many of them have later come to you to help you enforce that in the courts?
Yeah, we haven't had one of those at all.
Yeah, so that's what you're doing here. You're buying insurance.
Knock on wood.
All right, David, please.
Yeah, I was just thinking, Richard, about the mechanic shop a friend of mine owned, and his sign used to say something to the effect that his rate's $100 an hour, but if you want to help and give advice, it's 150 an hour. So yeah.
Yeah, there's a reason for that. Yeah.
So I was just wanting to mention the length of the average ownership agreement. Mine decided to do mine with a 5-year term because that was the mortgage. We had a 5-year term on the mortgage. So at the end of the term, year 4.5, we talk about, well, what do we want to do? So I'm just wondering, from your point of view, having done a lot of co-ownership agreements, what kind of terms, length of terms is normal?
Yeah, it really varies. I mean, we don't tend to have terms in most of them unless there's an investment play uh, where one of the partners may be saying, look, I'm into this, or or because we do co-ownership agreements where 3 investors come together and buy a property. And they may have an agreement that says we'll revisit in 5 years, and the option is available for someone to request either they get bought out or that in the fact the property is being sold. So very seldom in the family situations do we see a term associated with it.
Now, what we often know, I think I see people do is have a lockout period. So you can't force a sale for the first 3 or 5 years. Is that something that you encourage?
Absolutely, absolutely.
And the reason I mind that, I mean, just generally would be so that the emotional and the economic costs of buying and selling real estate are quite high. So you generally want to be in for 3 to 5 years to either to get past your costs of buying and selling, property transfer tax and commissions, or to get through a down cycle in the market historically. So generally, again, history is no indication of the future, but generally, if you hold for a minimum of 5 years, you'll be selling at a profit, and not feeling resentful about having done this, and then a year later being forced out of it. So,
And that's particularly common where it's not family too. You know, three couples coming together, it becomes even more critical there.
okay. Now, you talked a little bit about the challenges about being on title and about having to then put your name on the mortgage and all the challenges, can't get a car after that. Talk a little bit about a bare trust agreement and other models by which you can co-own but not be on title.
Yeah, so you know the concept behind a bare trust, and I guess we historically have done this as part of an estate planning process, where we'll put a child on title with a parent um, to avoid probate, so that they'll go on title as a joint tenant. They will sign a bare trust document saying, "Yeah, I'm on title," which is legal ownership, but I hold in trust for that parent, and the real value of the property is the beneficial interest. So it's still the parent's principal residence. The principal residence exemption applies. It's simply there to avoid the probate process. It's like a child going on bank accounts. I mean, everything my mother owns, I'm on the account, the investment accounts and regular bank accounts, but I hold in trust for her. Now, the only challenge has been is that and is the federal government is going to require a T3 file, trust filing every year on the bare trust. So for some people that don't use an accountant, that just creates an added complexity. So that's the concept of a bare trust. I'm on legal title, but I don't have beneficial ownership. The challenge is you now, so what happened for 2023, you're supposed to file, I think it was by the end of March, a T3, and 2 days before the deadline, the government said you didn't have to. And guess what? People working with accountants had already filed and lawyers had already filed, and now that just created tremendous chaos, but they have indicated that they are going to want to have that happen going forward. This is all about trying to get who is in fact behind. Is Richard Bell holding property for the Hells Angels? Now, I'm not sure that the bad guys are going to tell the truth. But anyway, so that's what the concept of bare trust. We're using a structure now that's, I call it creative, and I don't think very many people are doing it. What we're doing is we're actually having a transfer signed to the child, but we hold it in escrow. And so that we're not actually registering in the land title office, and that transfer is not effective until death. So we think we can avoid the tax filing because not even legal title has been transferred at the time of signing. So, it's the old story, and what happens is that, government changes legislation, and accountants and lawyers try and find loopholes. And then the government finds those, blocks those loopholes, and then you look for more loopholes. So, but yeah, so for families with an aged parent, we do look at ways to avoid probate. There's also things called joint spousal and alter ego trusts where assets are rolled into those structures to avoid probate or to disinherit the bad child, for example. So,
what about the flip side of that? Somebody who wants to be a co-owner but doesn't want to be listed on title. Maybe it's, I mean,
yeah.
for
Now,
many reasons.
remembering that if someone needs a mortgage, there has to be full disclosure to the lender. And now there's supposed to be full disclosure to the lender, and wherever there's a bare trust and it's dealing with land, we have a couple of years ago new legislation, landowner transparency registry, where if you're holding in trust for someone, you must file under provincial legislation that you're holding in trust for that third party. And this is an international, BC was one of the first ones to do it, but internationally governments have agreed that they're all going to roll out well, not all governments, but the developed world that are not Russia or China, I guess, are going to require these registries for who's really behind the ownership.
Okay. All right, a couple more questions, and then I'll do my kind of closing slideshow, and then we'll be here to answer anything more that comes in. With corporations and shares, does part of the property ownership become more difficult to define? The corporation owns the property. How is it determined what an individual owns?
Yeah, it'll be how many shares they own in the corporation. Now, the
Yeah.
corporation may be holding in trust as well.
Yeah, so the corporate, so your shares entitle you to that's effectively the percentage ownership in the corporation as a whole, and the corporate documents, in this case, it'd be a shareholders agreement instead of a co-ownership agreement, would define what rights those shares have. So if those shares entitle you to occupy a certain piece of the property, or to a certain amount of time per year on the property, all of that would be laid out in the shareholders agreement.
Yeah, and remembering that financing is more difficult too.
So Janice, did that answer your question?
Yes, pretty much. So then what about if a person wants to, like if it's divided into a part of the property or a part of a house, is the exit strategy harder? Like, do you have ownership in a sense to be able to deal with it yourself? Or I know sometimes it will be a matter of the company or the other shareholders will have the opportunity to buy first. If
That's
that doesn't happen, do you still have that control to then sell it yourself?
Yeah, it'll all be based on what's in your shareholders agreement.
Okay, yeah.
And so
Yeah.
everyone gets the, but again, it's just that challenge of, yeah, you can have it there, but what about the financing aspect? You literally go into a different department within a financial institution. And so what some people used to do is, because they could finance easily, they would they'd buy and borrow in a personal name, and then they would do a bare trust saying they hold in trust. And that was fine until the bank found out about it, and there wasn't, there's supposed to be disclosure, right?
So it almost seems to me that that kind of a setup can be more difficult than a strata. Strata seems more straightforward on more of a personal ownership, and then a person being able to sell. Is that?
Yeah, I mean, strata is always easier because strata allows you to finance individually and sell individually and have autonomy. It is a form of co-ownership, right? You co-own the building as a whole, but it's a form that has been around since '66 and that the world understands. The problem with stratification is that you can't do it on a lot of properties, or it's very expensive.
True.
So if your zoning allows you to stratify the property, right, Richard was just saying how the province has made this multiplex rule, and most folks are allowing stratified multiplexes. I don't know if Victoria has changed their tune, but like when they first announced their multiplex plan, it was non-stratified, so you can't do a stratified version there. So co-ownership is the hack to get around when stratification is either not feasible or is just really expensive. If you have an older home, to stratify it usually means taking it back to the studs, bringing it up to full modern code, and is just cost prohibitive. So co-ownership can usually create a more affordable pathway, or a pathway with existing properties, or if you're sharing in time instead of sharing in space, right? Like a vacation property or something like that. But if you have a pathway to stratification and you can afford it, that is certainly an easier pathway down the road.
So the co-ownership is a structure in itself then, is that correct?
That's correct.
Okay, thanks. Yeah.
And how that structure plays out is something that really is uniquely designed for your particular situation. So your question was originally about exit strategy, right? Can your partner sell their shares? How would you do it? So, as I alluded earlier, right, it's usually a three-part process. So the first part is first right of refusal. The second
Right.
part is the right to sell to a third party. And generally, we would advise in this agreement that that right to a third party has to be approved by the other members. So you can't just sell your shares outright to
Right.
Joe Schmo and then, whatever they'll think, screw
Yeah.
them. That's not always the case. Again, with vacation properties, sometimes you can just sell it and anyone else comes in. But if
Yeah.
you're planning in advance, we highly recommend that with approval piece. But also because just selling a share in a piece of property, without them joining on, it's not like it's a realistic option anyways. It's be hard to find a buyer who just wants to buy a standing share in your property without explicit rights to what that is,
Right.
what they get, how they're
Right.
protected when they want out, things like that.
Right.
And then
Yeah.
if your partners can't buy you out, or if let's say they're blocking an investor, the investor you brought in, they don't like, or you can't find an investor, then you have this third stage, which is forcing a sale of the property. If you have a lot of people, again, if you're looking at 12 different co-owners, right, can one person force a sale or not? That's a bit of a question you want to define, right, how many people it takes. But if there's 3 of you, you certainly will probably want that right. So again, these will all be worked out specifically to match what makes sense for your situation and put in writing so that everyone knows what that is.
Thank you. That's great. Thank you very much.
No problem. Okay, Sheila, you wrote, you had mentioned avoiding capital gains taxes / death taxes by putting properties into all the parties' names. I.e., rather than leaving properties in a will, could you elaborate on that, please?
Yeah, so we'll often add a child to title, and we will have them sign a bare trust saying that they hold in trust for mom. Mom passes away. We file a death certificate. The property then is in the daughter's name or the son's name, and they're then holding in trust for mom's estate. And the will still apply. They just don't have to go through probate, paying 1.4% of the value. If it was just in mom's name and she dies, the only way to be able to deal with that property is go through probate, which is provincial government process, and you pay 1.4% of the value of the estate. If you're registered as a joint tenant, you're holding in trust because you want to make sure that mom still has the principal residence exemption so that there is no capital gains tax. It's absolutely critical that that be documented. So if Revenue Canada ever comes along and said, well, we pulled title and you were an owner on title. Yeah, that's right. But here is the document that says I was holding in trust for mom. So there's 2 types of title. One is legal, who's registered, and the other is beneficial, who really owns the property. Okay, you do the same thing with bank accounts, and then you can avoid probate, avoid paying 1.4%. Everything gets into one or more of the kids' names, but the will would still apply.
And I'll add, again, talk to a lawyer or talk to an accountant for true tax advice. But the other way this thing plays out sometimes is, parents who are downsizing on their property, they want to, let's say, move into a laneway house to live a single story existence. As I understand it, Revenue Canada treats 2 houses on one property as 2 separate residences from a personal exemption perspective. So, instead of moving down into only 20 or 30% of your property and losing your principal residence exemption on your main home, if you bring on a co-owner as, a family member as a co-owner, then they can maintain that principal residence if they're living in it. Versus, I don't know how CRA treats rental to a family member, but certainly you can maintain all those capital gains exemptions if everyone who's occupying a piece of the property is an owner of their piece.
Yeah.
Okay, so feel free to keep putting questions into the chat or to raise your hand if you have one more that's come to you. In general, we encourage everybody who's been here. First off, thank you for coming and for these great questions and for considering this pathway for yourself and your family. if you know, if there's people you meet who think this would be a good fit for, again, co-ownership with family or even just with friends or strangers, please do send them to Coho BC. Let them know about our resources and our supports and our upcoming events. But for yourself, do check out our website, our guide to co-ownership, our outline of the things that go into the partnership agreements. And it's not listed here, but I highly recommend our YouTube channel, where we've had, this will be posted this session and also other sessions like it in the past with other lawyers, members of Richard's team and others, where financiers, where co-owners themselves talk about their experiences, about the pros and cons. There's a lot of really useful information in there. If you want to know what's possible on your property, or what's possible in terms of acquiring a property as a family in your region, do consult one of the Coho BC co-ownership professionals. Again, the first line of defense is usually one of the realtors in your region, because unlike Richard, we don't charge for the hour up front. But highly recommend, bringing in those lawyers, especially if you're dealing with a property you already own and don't necessarily need the full real estate services. Richard is certainly available, and his team, Ryan Griffin, who's one of the best in the business. And then on our website, we also have other lawyers and other professionals that we can recommend as well. If, for example, you do need a second opinion, right? You decide you do want separate lawyers, so one can draft the agreement, the other one can review the agreement, things like that. So if you're in one of the areas mentioned here, we can connect you to one of our local first stop real estate agents, or just reach out to the Coho email address with your situation, and we can figure out what's the right connection to get you moving in the right direction. We do have a lineup of events happening in the months to come. On tomorrow, July 23rd, if you're in the Kootenays, we have an info session about a really great opportunity on this kind of massive 6,500 square foot house on a beautiful 18+ acre property that would be ideal for some sort of co-housing community or tiny home community or farming based community, or even for one large family if they wanted to come on, build a secondary home on the property, have this great huge family home and great acreage. So that's tomorrow. We're doing shareable homes tours on the Sunshine Coast and in East Vancouver coming up, which is a great opportunity to see the kinds of housing, get a sense for what it looks like in reality, to see homes with multiple suites in it or homes with laneway homes, understand the market and what's available in your region. Also, it's a chance to meet other people looking for this kind of ownership. But again, if you have your own crew, it's a great chance to just come and see what's available. But also, again, contact one of the Coho agents. We can certainly set up a private tour for you and your family to go see what's available on the market. This says September 24th, but it's actually been moved to October 1st. Apologies. The What is Real Estate Co-Ownership info session. We talked specifically about family co-ownership here, but we do have a really great introductory co-ownership presentation that goes through the legal stuff we talked about in a little more detail, goes through the financing and the delinquency stuff, goes through what the process is like to kind of come to vision what the real estate looks like that's available in the province. So if it's your first time with Coho and you want to learn more about real estate co-ownership, you can come to that session on October 1st, or you'll get a link to a video of a previous info session that you can just follow up to watch it at your own pace. So that's October 1st, not September 24th, as said here. But that's the end of the presentation. It looks like some more questions may have come up, so we'll take those. I just want to thank everybody who came. If you sign off, you will get a recording of this session. It will be uploaded to YouTube and available on our YouTube channel, and a link will be sent probably tomorrow in a follow-up email, the thank you for registering for the event email, so you can see that. And you can certainly share that with others who you think should be seeing it as well. So it looks like all the comments here are thank yous. Thank you too. Are there any other questions from anybody, or else we'll let you get back to your evening? And Richard, your email address is here on the screen, so people should reach out to you directly as well to talk about their personal situation.
Yeah, and if you're thinking about doing co-ownership and buying a new car, buy the new car first.
Yeah. Normally in real estate, they tell you get rid of your car loan because it cuts into your ability to get a mortgage
Yeah.
quite significantly. But in co-ownership, it's buy that car first. Exactly.
Thanks to everyone for participating, and you've got my information there.
Thank
Thanks
you.
so
Thank
much,
you.
Richard, for your time
Yes, thank you, Richard, so much.
and your knowledge.
Have a good night, everybody.
Okay.